Good evening, everyone. Welcome to the Harrison Township Planning Commission meeting. Today is Thursday, February 20th, 2025. We'll call the meeting to order at 7 o'clock. Roll call, please, Ms. Oparka.
Member Bacha.
Here.
Member Devlin.
Present.
Member Duncan.
Here.
Member Vizenko.
Here.
Member Tominello is excused. Member Oparka here. Chair Murray.
Present. Thank you. May I have approval of the agenda as presented, please?
Motion to approve.
Support.
Any discussion? All those in favor?
Aye.
Motion carries. Approval of our minutes from our last meeting, January 16th, 2025.
Motion to approve. Minutes are submitted.
Motion by Mr. Vizenko.
A second.
Second, Mr. All those in favor?
Aye.
Opposed? Motion carries. Our first item this evening is unfinished business. Ms. Oparka?
Case number 1-25-SLU, Huron Point Excavating, 32490 South River Road. This is for temporary use of a storage yard for miscellaneous equipment and materials.
Excellent. Hi. You want to come up and give us your name again, please?
Hi, Crystal Roush with Huron Point Excavating.
Okay, and you were here a month ago, and we tabled this case to allow additional information to be provided, and we have received the permit from Eagle and some additional information. Mr. Young, do you want to give us a recap?
Yes. I can go through the listing of the additional information that we've been provided.
That would be good.
So up on screen, we have a revised site plan that they've submitted. They've included additional detailed information on this site plan. I've got a bulleted list of some of the major revisions or additional information that's been provided. One of the things that they've done is they've moved the proposed stockpile area for the dredge spoils to be 20 feet from the southern property line, as opposed to directly on the southern property line. So that's this portion of the site right here. So they've moved this to be 20 feet further. They're now showing the existing vegetation on the site with the note that this existing vegetation will remain. To the extent kind of in front of this stockpile area and south toward the waterfront. The storage area, though, has not been moved. It is still proposed to be sitting, from what I can tell, directly on the property line, the southern property line right there. They did provide additional details about the screening for this area. This fence, they have a picture of this fence, a picture of what it would look like with the kind of fabric screening. They also have a detail of the chain link fence cross-section detail as well. They've provided photos kind of highlighting existing conditions on the site. Also here, some aerial bird's eye view photos as well. They provided a detailed listing of the equipment that will be stored, or that may be stored within the storage area, to include these pieces of equipment here. They've also provided a layout generally of where the equipment would be located within the storage area. They have indicated that site lighting will occur, that they are going to install 3 parking lot light poles and fixtures, they say. And they've also provided a restoration plan that is kind of in this narrative here. This narrative also has additional information just about their operation, scope of work for the project. More information, like I said, about the operation, the property. They've also provided a copy of the Eagle permit that has been received. They've also indicated what additional permits they will be securing, including the Army Corps permit, the soil erosion sedimentation control permit from the county. They've provided, the purpose for this project, the activities and traffic levels. So they've kind of provided an estimate based on their the scope of their operation, their hours of operation, the number of employees that will actually be located there. 5 employees are occasionally, these employees, they have 6 total employees. 1 is an office personnel, and they say 5 of the employees occasionally may meet at the yard to get daily supplies needed before heading to the job. A little background on where we're at, how we got to this point. And as I said, here's that restoration plan. So essentially the detailed listing of what they will do after the 3-year period is over. And that's what they've indicated to us, that this is a 3-year operation, temporary operation. And here's the timing, essentially over a 4-month span, how they'll restore the site after the 3-year period has ended. So, we've in the letter that I have in your packet, it has the items A through E. These are the kind of evaluation factors that you, the Planning Commission, would utilize in order to make a decision on the temporary use. They're really just kind of a couple of things stemming from comments that I had brought up at the last meeting. We had asked for more information about their restoration. What does that mean? How will you do it? How will it be accomplished? So they have provided additional information about that. A couple things on the site plan. One of the things that I was concerned with or had brought up as maybe something that we ought to consider is the proximity of this. As I said, they did move the spoils piles 20 feet from the property line, but the storage area itself is still on the property line. And then lighting, this is something they added information about lighting, but we just need to make sure that it didn't say like how, for example, how tall is the light pole, that kind of a thing. So the ordinance limits light pole height to 25 feet. So we would just want to make sure that anything they put there does not exceed that. And they have, just general comments, again, about this operation. We know that if this was a permanent use, marine contracting and outdoor storage is allowed in this zoning district as a special land use. We've talked about, is this consistent with the, adjacent properties and things of that nature? I think ultimately, the Planning Commission, you have a decision as to whether you feel that it is, or maybe if there are additional things that you could add as, contingencies or conditions to ensure that it does. And then, again, I just wanted to refresh your memory on this, the approval process and what you can do as a Planning Commission for a temporary use. So this section of the ordinance says that you can approve a temporary use for up to 5 years. If you wanted to limit it to 3 years, you could and probably should, because they've indicated they only want 3 years. But you can also require annual compliance reviews, and we've done this with other temporary uses, where they're required to come in, after 1 year's time, appear before us, and then if there are any issues or problems, then we can ask them to, address this or address that. Or ultimately, you do have the ability to withdraw your approval or essentially rescind your approval. So with that, I guess, Madam Chair or Planning Commissions, if you have any questions for me, I'd be glad to try and answer them.
Thank you. One of the other items that we received was the information from the Macomb County Department of Roads indicating that, that a paved approach is required with a decel and tapper lane per Macomb County Department of Roads standard detail. I didn't compare that to the plan, but that appears to be required. And so I thought I had read that pile of what they're going to be hauling out of the lake, the muck.
Spoils?
Yeah, thank you, the spoils. That will carry an odor, piled up, and certainly with the sun and summer months and so on. I thought I had read that was going to be hauled off-site. I read a lot of information, so. Are you able to?
Yep, I just didn't want to cut you guys off when you were talking. So the storage area, as for the fence line, we haven't put up a fence on that side of the property. Currently, there's just like a 4-foot high chain link fence up there. If you guys would like a 6-foot high fence, if the SLU is going to be approved, then sure, I guess, we can put up a 6-foot high chain link fence, 5 feet away from the fence that's on the property line now. As for the lighting was going to go on top of the toolbox sheds. So that's, the lighting would sit up on top of those. I didn't want to put lighting all over because there is residents, and kind of be respectful. There is the trailer park that's adjacent to our property, and that back road has lights. And then at the entrance on Jefferson, there's 2 street lights kind of at each corner of the property. So that portion of the property's lit up. The muck will be trucked off site. It just has to sit to dewater before it can, because it's like a soupy substance. And then the dirt and whatnot's gonna remain there to be used to restore the property back to your conditions.
So as the spoils dry out, then they'll be hauled?
Yes, yep,
Okay.
yes.
Okay, thank you, I thought I'd read that. Okay, so what, does anyone have any questions regarding that while we're on that subject? Because I want to dive right into the fence. Okay. Our ordinance calls for fences to be placed on the property line.
Okay,
And so placing a fence 5 foot from the property line where there's already an existing fence is going to create a maintenance issue. Who's going to maintain that barrier
okay.
on a regular basis?
So are we good to use it as it is now?
Well,
That's-
I don't know, we can talk about that. That fence that's on the property line is covered with vegetation, correct?
So the
overgrown?
vegetation pretty much stops. That's where the end of the storage area goes. There's a big tree, and that's kind of where they finished off the storage area and fenced it in at. So the vegetation that's on there, that's it for the back. In the front, there's some like phragmites and stuff that go along the property line and the fence, just in that front corner, and then it goes out to the front part, not in the storage area. It goes like into the grassy, the front lawn, I guess you would call it. But the rest of it's pretty much open.
Yeah, I see that.
Madam Chair,
Yes, sir.
I wonder, I don't know, did I hear you correctly? Did you say that there's already an existing fence there?
Yes, that's
That's-
a 4-foot fence that goes along that entire property line.
Okay. But you are proposing to remove that and replace it with the
Well, we were gonna
6-foot
use it
wall.
as it is, the existing fence was gonna remain, but if you guys want a higher fence, I didn't know if the residents were complaining and wanted it, and that's why you guys were asking for it. If we could leave the 4-foot fence there, use that. If not, we'll put up a higher fence if that's required.
Well, our fencing, while it's the V1A,
Well, this is a temporary use.
it's a temporary, right, so
The-
that puts a bone in there.
The screening is really up to the planning commission's discretion.
since it is right next door to and literally right next door to residential, the height of the storage equipment is certainly more than 3 or 4 feet.
Yes,
So the view is fence
Yes.
and then equipment.
yes,
And some of that equipment is higher than 6 feet.
absolutely. The
Although 6
booms
feet
on
would be
some of
a-
them are 18, 17, 18 feet long.
A majority of your storage equipment is on the other side, next to the mobile home park.
Correct, yes.
And then you have your trailers in front.
Yep.
Oops. Well, personally, I think a barrier is better serves the residents, especially the ones that are close on that side. On the other side, there is a driveway between the property and the mobile home park. I don't have the property line pulled up on this one.
I think as I was looking at this site plan, and I see on one property line, they have a 14-foot setback. And then the screening fence begins. My question obviously is, why couldn't you have a 14-foot setback on the other
On the other
side?
side, and the
And the
screening
screening.
fence.
I'm not saying to do anything with the existing 4-foot fence, and you probably be a mess to try and get rid of that since it's overgrown and whatnot, but.
Well,
You know, that was kind of my
Yeah.
comment. Now, I don't know what of this storage area, if the gravel material has already been placed there.
Yes.
I assume
you,
maybe
I
some
think
of it
you do
has
already have,
Yeah.
you have a majority of the gravel or all of the gravel down?
It's all down.
It's all down. And it's right up to that, is it right up to that fence?
Yes. I mean, I can plant some viney stuff on the fence over the summer if that's what they're seeking, or I don't know what they're,
I would like a 6-foot fence. I think a 6-foot fence is minimal placement. We're required, township ordinance calls for on the property line. Where the storage area, we can dictate that they place their equipment, you know, a certain number of feet away from the fence. I mean, we have that ability.
I think that may be something to consider. And by the way, their site plan does show a 6-foot tall chain link fence with the screening around the
Yeah,
entirety. So So based on what they're telling us on this plan, that 4-foot chain link fence will be removed and replaced with the 6-foot tall chain link fence.
Okay.
That's what their site plan says. But maybe that is, you know, something to consider, like maybe you would ask for, give us 10 feet from the fence line itself along that southern property line, or whatever you would like to do, I don't know.
Here's my only comment about this, is that this is still a temporary use, and so like, once it's vacated, do those residents want a 6-foot fence there, or do they like the 4-foot, you know what I mean? Like, that would be my only thing. I think a 6-foot fence is necessary. I don't
Under
think
these conditions,
moving the
yeah.
equipment really matters, because if you look at their detail of what it's gonna look like with a
6
6-foot
foot's not gonna
fence,
hide a
you're
whole
still
lot.
gonna
Still gonna
see
see it.
all
Well,
that crap.
If you're sitting at your kitchen table looking out a window, if it's further away, it probably would be more visible. 6-foot fence or not, right?
Well, it could be restored, you know, the 6-foot fence could be removed as part of the restoration plan.
Maybe they like the 6-foot fence.
Maybe they do.
Well, and so our parameters are the 3-year term, which is what's called, I don't think we're looking at anything beyond that. 3-year term, and if they remediate, if they're able to remediate prior to that, then anything occurring to the property has to go with what we approve, right? With what we define. But I'm just throwing this out there. What happens if somebody buys the property and they want to keep the 6-foot fence? Are they bound 100% by what's decided on the original remediation plan for restoration to the property?
And what is the surety that the restoration plan will in fact occur as stated? Because there's a lot of detail in
Yeah.
the plan. So what is the surety and who is it that's going to be checking to make sure?
Well, I like the annual compliance review. I think that's a must. And like you had said, we do that for a few properties in the township. So there certainly could be, in addition to that, a remediation follow-up for validation.
Okay, but is there like a legal means to guarantee? the
Yeah,
surety?
at this-
Is there a
at this
bond,
point,
like
they
a
haven't-
restoration bond?
They haven't offered that. That's not, and I didn't see anything in that restoration plan that was like, yeah, we're willing to put up a bond or a surety.
Yeah,
To ensure.
because no offense to the applicant here, but just looking at all the options, say they find this really awesome piece of property, in Algonac, and they decide to move in 2 years. And they don't care anymore, so is the existing property owner who shows that he doesn't care about maintenance, what's gonna force him to make any change? Then we'll again just be waiting for some rich developer to come along someday and do the things that we want to see at the gateway of our community.
And that, I think Rosemary is looking to see what we might have in the ordinance, but certainly in the past, especially for a special land use, which this is what it is, requiring a performance guarantee or a bond or some letter of credit of some sort, that's held, and it would essentially say that if it's equal to the value of the restoration work, and the township would hold that.
And that's
It would be
pretty
returned
typical.
once it's restored by the applicant, but.
That sort of bond is very common when public improvements are constructed or any sort of thing that the township or the city or whatever doesn't want to take on the burden of the restoration or the construction themselves. So that's something that I would be looking at. But can I just make a couple comments?
Oh, gosh, yes, please.
So I really, again, no offense to the applicant, because I read your documentation and you were issued a building permit, the applicant was, but I really have a problem with the township issuing a building permit in this case. It says right on it, zoning compliance review. That doesn't seem to have happened at that point, and the building permit allowed the applicant to, thinking that they were okay to go ahead and do what they did. So it makes it seem as though it was a mistake that it was issued, and through no fault of theirs. And it really creates a hardship for the applicant. It really creates a hardship for us, and it really circumvents the public process. So I hope that there can be some sort of communication with the township to not issue these building permits without actually going through the zoning compliance review that they put on that document that they said they did. So that's my first comment, because, that's a big deal. And then, so one thing that we've talked about, Amanda and I were on a resilience initiative with the city of St. Clair Shores. And one thing that the county has talked about and the lakeshore communities have talked about is almost every bit of the shoreline is armored with seawall. And this is one of the few areas that isn't. And we're really trying to encourage the reduction of armoring in hard shoreline. And here we are as a township saying, let's go, let's put some more seawall in. So I see that one of the conditions is to remove the seawall. But again, it's one of those things that once it's there, it's really hard for people to want to remove it. And it seems like that's something that would be very easy for a township official or whoever is doing the, checking for compliance on this to overlook. So I would want to be very sure that if seawall was installed, that it would be removed at the end of the period. And then again, I just want to reiterate that, this township has a DDA, and the DDA is working hard to improve the gateways to the community. And this area is just south of that, but still, it is a gateway to the community. And it feels like this project in this location, even for 3 years, is going backwards, not forwards. And again, I'm sympathetic to the position that the applicant was put in this case. It's not fair. Anyway, those are my comments, and I would not be able to approve it without some sort of bond or other surety that the restoration would occur as what's proposed. And it's very detailed, so it's gonna
Verified
need, it's gonna need a lot of attention. And I'm not sure the township has the capacity to do that, at this point at any rate. That's my 2 cents on it.
Madam Chair, under the building code regulations, it does allow for the building official to require the developer, builder, homeowner, or applicant to deposit with the township an amount reasonably necessary to ensure that that person, completes its obligations under the code and township code and ordinances, which would include the zoning ordinance. Under section 1, where it does include special land use proposal, special development options, all kinds of plans. So they could be required to post bonds to ensure that, the fence is removed, everything else is, the remediation plan is completed.
And I'm thinking maybe it should be the actual property owner, if there's a way to do that, because if the applicant, finds a better gig, they're gonna be gone, and the property owner is gonna go, oh, well, I don't know, they're gone, I don't know what to tell you.
Well, it's usually the person that's doing, it's developer. Sometimes it's homeowner, but if it's their own particular lot, so it's usually the applicant that's doing the work.
But do you recognize that that's a valid concern, or it's one that
No,
it
because
would go away
if you're
with the bond?
posting a bond, that applicant is gonna make sure that they do it to get
Okay.
it back. It's sufficiently posted.
So it doesn't matter who does
Right.
the bond, it'll still be
It
done?
should be the applicant, because they're gonna wanna get that money back at the
Okay.
end of the 3 years.
Understood.
Couple questions. We're showing on the building permit, and I noticed on the paper, we've got addresses of 35890 and 35896. Obviously, 2 different parcels. What work is being done on 896?
It's the 2 parcels that's split in the middle, that whole lot is,
Okay, so 2 separate parcels,
yes.
okay? Your building permit is for 890, correct?
Yeah,
What I'm showing. What work is being done on 896?
the half of what's up on the
Okay.
board.
Would a building permit be required for that property?
And
Is it one address for 2 lots?
no,
No,
it's
there's
2
2
separate
separate lots.
addresses. But the permit for parcels, the parcel number on I don't know if this is just a typo, the permit, or the parcels listed are identical. So one parcel ends in 007, one parcel ends in 008. Both parcels listed on the permit end in 008. But
And I mean, maybe it's an oversight, but just a
but it is,
question.
right, it is one address,
One address, so you're gonna get one parcel number.
yeah.
It could,
I think it's an error here. I think it should be 07 and 08, and then one address. So I think there's an error on the building permit.
And whether it's an error, really for our purposes tonight, the building permit, the fact that it was or wasn't issued.
yeah, okay.
Shouldn't affect your decision tonight.
And even though it's a short-term 3-year special land use, I would be on the understanding that they still need to meet the 8 standards of special land use, correct?
So I would argue no. This is a particular section of the zoning ordinance, section 11.14, and it outlines special standards, 5 of them, for these temporary uses. So I don't believe you would want to go and apply the 8 standards that are applicable to a permanent special land. You would want to apply these 5 standards for this temporary use request.
So 11.14 under temporary
Correct.
structures, tents, and uses?
Under, actually subsection 6 is temporary uses.
Well, I wonder if the temporary use ordinance was drafted with the idea of such an intense temporary use. I mean, it's not quite a fireworks
All,
for a month.
yeah, I guess we don't know what the intent was. We can only read what it says. That section essentially says temporary uses may be allowed for up to 5 years. It does say, one of the standards, standard B, is that the granting of the temporary use shall in no way constitute a change in the basic uses permitted in the zoning district, nor on the property wherein the temporary use is permitted. So that only tells us that is it one of the uses that could be allowed under the zoning district? The answer is yes. It doesn't say that you can't grant a temporary use for a special land use allowed in the zoning district. So that's all we can kind of go by.
Well, and D kind of gives us our bucket of considerations. All setback land coverage, lighting, off-street parking, and other requirements are to be considered in order to protect the public health, safety, peace, and general welfare of the inhabitants of the township. So that kind of gives us our go-to list.
And then further, that last sentence is also very important. All such requirements shall be established and made at the discretion of the
Yeah.
planning commission. So it means that we're not applying necessarily the strict standards of the V1A district. But it's encouraging you that you have discretion to apply height, lighting, parking, and other standards as you see fit for this particular use, given its context.
Well, why don't we tackle, if the commissioners are good with this, why don't we tackle what we want? What is an absolute requirement? Start there.
Can we, Madam Chair, can I just make a few comments?
Sure.
And following up on Adam, what he just said. Understanding that this use would be permissible under special land use approval, but something I'm looking at in the findings here is subsection C, the use shall be harmony with the general character of the zoning district. How do we put this use and incorporate it and say this is harmonious with the surrounding areas when it's all residential and this is an industrial storage yard?
Well,
So I get that it's
And it's
a-
not supporting a mixed-use, pedestrian-oriented, integrated waterfront district with a unified nautical base.
the use under normal pretense, if it was harmonious with the area, surrounding areas would be permissible, but right now this is not harmonious with all the residential. You've got the residents right to the south, right on the property line, right by that 6-foot fence, right by all the equipment, right by the spoils, and then to the north you have more residential, so.
Then we've got the V1A Village District Section 14.21, which allows for permitted special land uses of the waterfront district not otherwise listed as a permitted use in the V1A district. So
If it's,
we're kind of in a,
but if it's harmonious with the surrounding
Right.
areas,
Right.
that's where, I'm just trying to get past this point before we start talking
so what
about
is our,
conditions of
what
approval.
takes precedent? The V1A as the starting point or the temporary use as the starting point? Because they are in conflict, and we have to find a melding of the two.
What do you mean by that?
The V1A
Yeah.
indicates that this particular request is allowable with a special land use granting.
Correct?
And so, under special land use requirements, the
Right.
8 factors. But this is a temporary use.
Right,
So V1A sub-temporary use.
right.
So that negates the 8, and then we follow the temporary use parameters? I mean, in my
Yes.
head, I see that.
You follow this-
Hierarchical.
Yeah, you follow the temporary use parameters,
And those are 5 conditions.
those 5 conditions.
It has to start with the base zoning, in my opinion, you know? I mean, no matter what the temporary use rules are, if it's inconsistent with the base zoning, And those things that are permitted either by right or permitted by special use after consideration of those things that, whether it is harmonious with the neighborhood. So it seems like the base zoning would be, if you find that it is consistent and harmonious, then it would be looking at the temporary use rules, it seems to me. But I mean,
Well-
I'm not the attorney.
The use shall be in harmony with the general character of the zoning district. That is one of the special land use
Yes.
standards as well. So that is
Number one, I think.
both. Is both.
There is a little bit of an overlap between the 5 temporary use and special land. Nonetheless, the V1A allows this type of use as a special land use in that zoning district. So there's your base. Is it allowed in that zoning district? Yes, as a special land use. You're not approving it permanently as a special land use. You're now looking at it as a temporary use. So it then shifts to 11.14, and then go from there. Because it is temporary, it's not staying. That's the intent, and you can put whatever conditions you want on it under subsection D.
So perhaps where I'm getting a bit hung up is, I'm going to reread the line that seems to be the one getting most of the analysis, but I think it's applicable. It says the use shall be in harmony with the general, and here's to me the key word, character. It doesn't say it shall be in harmony with allowable uses within, it just says character. I think that, to me, that's the word that's driving me more towards going back to V1A and looking at V1A and looking at what the permitted uses are, because to me, that sounds like character. Okay, and a special land use is not a character to it. It's allowable, but not character to me. So I'm likewise getting a little bit hung up with,
But storage, permitted and special land uses, item 11, under other uses, under section C of 1421, I did not see any other category that fit. Please correct me if someone sees differently, but I marked 11, permitted and special land uses of the waterfront district, not otherwise listed as a permitted use in the V1A district. So that's kind of the catch-all.
Yeah, that's where the marine construction, maintenance equipment, use, and
yes,
storage.
that's how it finds its way in, under a special land use.
That's
That
where,
means you have to consider the character of the neighborhood to determine if it matches the rest of those areas surrounding it. I mean, I'm kind of quibbling with it's allowable, because it's not. It's not one of those uses that is permitted by matter of right in the district. The whole fact that it has to be a special use means that we are charged with considering whether or not it fits with the district, with the surrounding neighborhood, whether the scope is going to be harmonious. So just that in and of itself, to me, it's not a given that it's an allowable use.
and you do have two standards. I mean, standard B could be is it one of the allowable uses in the district?
Permitted by
And then you
right.
could say, well, standard B here just says, it can in no way constitute a change in the basic uses permitted in the zoning district. So even if you said, okay, because it's a special land use, okay, it meets B, you still have to approve C as well. So the comments that multiple people have had about, is this in harmony? That may, yeah, I agree, maybe, we're not talking about use for subsection C here. So you're looking at character, so.
Well, I'd like to, and that's why I thought maybe the place to start would be, let's look at the requirements. Let's look at what we are requiring for this applicant and this piece of property. And do our check marks from that point forward and see if we can find ourselves within, the parentheses of what they're asking for.
I mean, I'll make the comment up front. I'm not going to get past C, and I'm a no on this. Totally.
Well, we
So
are,
I'll go back. So on B, I read, the granting of a temporary use shall in no way constitute a change in the basic use of permitted, okay, fine to that concept. But again, to me, when I read the word basic uses, I'm back to what is actually permitted without the use of a special land use is considered to be basic.
Okay.
Right? I mean, that's where I'm kind of trying to rationalize my own head. How can I start to categorize these thought processes in order to get someplace? And when I see the word basic, that tells me it's the 26 items listed there that are permitted uses within V1A. And what we're doing is not permitted, so now this to me circles back to, maybe you still gotta look at special land use. Because this is not even permitted under a keyword, basic.
And I'm gonna just play devil's advocate. I don't believe that marine construction is a permitted use anywhere, other than a special land use approval. Thank you. In this district.
Fair, but now we're, so then you'd be back to, if that was the only consider it under a special land use.
Same issue with.
So now we're back to saying we can analyze it as a special land use again.
And
that's
if
what I'm
you
not getting
want to
past.
start with special land, I would analyze both then. If you do both standards.
Oh, the 8 and the 5.
But
Right.
We're gonna still be hung up on the same.
We'll still get hung up in the same areas, though. They're still gonna get caught.
And we already got hung up on the same business, the same use on a different property in the township.
Because C under temporary is gonna be a hang up.
Yep.
And then whatever they are under the 8, I know there's gotta be at least 2 within the 8 that'll get caught into that same, situation. Whatever they are, I don't remember off the top of my head, but I know they get into similar concepts.
And I get this as a temporary use, and the whole restoration plan kind of gives me a little bit of a hang up because the property's gonna be restored to what it was, okay? Well, could it be restored to something better that, like, we're left with that someone might actually wanna purchase and build something?
Or live next to,
Live
Yeah, I'll live
next
next
to.
to.
or drive by.
You know, the seawall you brought up, like, that's a big expense, like, taking it out, yes, I would prefer that, but that's also, if it was left in, you're gonna
That's a
increase the
huge selling
property
point, yeah.
to some-
The state's requiring it to be removed.
Okay, which makes sense, because they don't really permit.
Yeah.
They want softened shoreline as well.
So, okay, so let me ask this question then. Under general provisions, 11.08, outdoor storage and merchandising, item B, outdoor storage and display lots, but outdoor storage. When permitted in a particular zoning district, an outdoor storage use shall be enclosed in an approved masonry wall or obscuring fence, a chain link fence or landscaping earth mound, both with intense evergreen shrub planting may be permitted. Open storage areas shall be hard surfaced with suitable so we're provided with direction. We just have to determine which set of rules are we going to apply. And again, that's why I want to go back to what are we requiring? If we can tick those off and then compare those to the 5 standards and/or the 8 standards, that may give us a common ground.
Maybe not to beat a dead horse, but Danielle picked on this a little bit, and so did Amanda, to some extent. Perhaps any other district other than V1A. V1A, which was put into the zoning ordinance to be this really unique entry into the community.
Beautiful, welcome to our township.
Right, and it's like we're going to take a V1A district and turn it into a temporary storage marine. It's like, anything else, you could almost start to convince yourself that, yeah, maybe, but this, the thing that was put, like, the big child to make the entry to the township, we're going to make, that's around, I'm fighting with that one, too.
And it is, and it's unfortunate. I mean, you and the owner of the property who indicated he was a real estate guy and is searching.
We've been actively searching.
Yeah.
In fact, one of the gentlemen that was here, that was opposing us being there, he has a property for sale that we've been
trying to negotiate on that.
So,
That's interesting.
Well, that is interesting. It just seems like,
Well, how long,
It's
how
a-
far off is that?
well, yeah, exactly. This
We are
is a lot of money.
active.
This,
We are
this
actively
listing
seeking.
project is a lot of money putting in, and then a lot of money to remediate.
a
Restore it
bond.
back to, yeah. I hope the excavating business is quite profitable for you.
Not this
That's-
time of year.
we work all year round,
Yeah.
thankfully, yeah. Thankfully.
Well, and again, so I go back to, why don't we take a look at what's required? And start there, I mean, unless someone has a better way to approach this.
I mean, I'll also echo that getting past C is going to be really difficult. And whatever number it is in the special land use, and now,
I
like
think
I
it's
said, this,
1 in 6 or 1 in 8, it might be.
8 for sure.
8.
this same use and the same scenario has already come to us, and that's, for me.
And we tripped on that the last time.
We tripped a lot on
Yeah.
that, and now, they're in talks with another property, and what happens to everything we required on the
Well,
last property?
And that's a good point. So if we take into consideration the fact that this is a temporary opportunity, and if we label it as 3 years, that as the applicant has, provided to us, 3 years, are we setting, if we find that we can work ourselves into this, are we setting a precedence that's going to cause an issue in the future for items that don't meet the 8 standards for special land use? And especially, what was it, 1 in 8?
At least
I
8
had
for
it.
sure.
Yeah.
That's a good point. Just call it temporary.
Right. Well, right, so it's, I mean, this is,
You can do that a
3
few
years is a
times.
long time, but it's still temporary.
3 years is a longer time when you're living right next to it.
And the temporary uses that we normally approve, although we did, the Eagles Club, their tent was temporary, and that got approved for decades. But now.
And now they have a permanent structure.
Permanent structure.
But it complies with the
Like
ordinance.
Danielle said, we're generally, for temporary uses, it's a fireworks.
A seasonal, right, it's a seasonal tent to sell plants or to sell fireworks or, occupying a parking lot that's going to take away from the total number that's required.
But if they find another property, they're gonna leave.
Yeah. And they'll have to remediate back to, yeah. All right, so how do we want to tackle this?
I would think if the majority can't see their way through number 5 of the temporary use or any of the other 8,
Then it's not even
then
worth
going,
it to
bit by bit through it
dive
doesn't make any sense.
into it? Okay.
Yeah.
Well,
I
we
mean,
can,
I think we had a bit of heartache approving the South River Road location
did.
a couple years ago, which we did, and I think that conformed a little bit more to the area that it was around. Driving by this the other day, not even close. I went by and went, whoa,
Yeah.
you got it. I mean, I was surprised, at the look of it. So I think, that conforming to that area does not meet.
Well, then let's start there. Let's tick
It
off
sounds like a
the,
motion almost. It almost sounds like a motion.
It does.
I'll make the motion of
Done.
case number 125 SLU here on Point Excavating be denied the special land use
and then declare why.
due to the non-conforming of item C, temporary uses, 14, whatever it is, 11.14, 6 temporary uses, subsection C. And if we go over to special land use requirements, 17.01 standards, 1 and 8.
D1, A through D, Well, no, we can't say, because that's just setting up the wall and,
It's C, I think is the one,
See,
and we have to satisfy all A through.
so not 1108. I'm sorry, let me come back to 1114,
6.
6C. And then there was a second one. I thought there was a second
If we go to the
one.
special land use,
Let me just do it.
those 8 requirements.
Oh, right. Give me that page number, please.
It is, actually, I don't have a page number on mine, 1701 is the.
I'm going to try and pull those up on screen here.
Oh, that would be lovely. Of course, I guess I could bring it up on my iPad, right?
Okay, this 8 standards are in section 1701, A, 1 through 8.
There we go.
At least 1 and 8.
There we go.
Standard 1 speaks to character, as does subsection C of 1114. Eight is
Yeah. 6 is the one that I ticked off.
8 is injury to the value of other property in the vicinity.
And 1.
possible nuisance emanating from which,
Legally, we did this for the sake
Order.
of the waterfront district. We went through these standards. Do we want to?
Specific to this
Okay,
location.
there's specific vibration noise, because I particularly remember us saying.
So again, our hierarchy is special land use, temporary structures. So we think we must comply with the 8 and then the 5.
I think we have problems with both.
With what numbers?
Well, so we're still in the middle of a motion. And so let's iron down the reasons for denial. I want to be very specific. Non-conforming, and citing 11.14C section 6 subsection C, and then the special land use 1701 section, standards, item 1. That's A1, and then I thought someone had said, D, the decision portion,
No, 1 and 8,
1 and 8, okay.
And I would say
and possibly 3.
3 and 6. No 6.
Okay,
A number of them.
all right, so do we want to talk about that, or are we leaving that?
This is-
I'm just gonna, I understand that you're like looking at things, what you feel don't meet, and that's wonderful. And I think you should narrow those down and focus on those, but then there should be facts that support each one of those.
So, okay, we don't have a second yet. So, motion by Mr. Duncan to deny case 0125 special land use for Huron Point Excavating due to the fact that it's non-conforming, citing sections 1114-6C and 1701 A standards 1, 3, 6, and 8. Do we want to clarify or get a second first?
I'd-
So, one more thing. Just to be clear for Melody, that the word non-conforming, I don't think you should use it, that the following facts do not conform, or, we find that they do not.
They don't meet the
presented
standard.
Does not conform.
Okay,
to
so
these standards.
not,
Don't use
okay,
the word
so
non-conforming.
because non-conforming is an already established term, okay.
Or it doesn't meet the standards.
I think
we're
one
saying-
meet the standard.
Does
3
not
and
meet
8.
the standards of the special land use standard under this section of the ordinance, 1, 3, and 8.
Okay.
And the following standards under the temporary use,
Temporary
whatever
temp,
ones you
yep.
find, and then the reason being, and state all the facts.
Got it?
And can we just clarify right now, and this is from the motion, we've got the standard C from 1114, 1, 3, and 8.
1, 3, 6, and 8.
No, not
I,
six.
I'm asking the person
Oh,
who's making
sorry.
the motion,
Not 6.
not 6. Okay, 1, 3, and 8. Okay.
Yeah, that's kind of our go-to.
And then do you want to state why it doesn't meet those 4 standards?
Sure, I say on the 1114C, it's just like we had discussed earlier, it does not meet the general character of the what's going on in the district. If you drive by there, to me, it just doesn't pass the eye test. As far as 1701A standards, number 1, same thing, being in harmony with the surrounding neighborhood, basically the same thing that we were discussing in the prior one. 3, the proposed site not being a nuisance to the area, as a lot of the people in the community have discussed, the people that live nearby that were at our last meeting, talking about the light issues, the noise, the sounds, the dust, just pretty much covers that part of it completely, what they talked about. And I don't see how the people, if somebody were to go to sell their property in this next 3-year time period, that they wouldn't be harmed by this endeavor with the property in the area.
8.
Number 8.
So we have said motion with the indications and the explanations of those indications. Do I have a second?
I'll support the motion for intent, but could you restate it again, just so?
I can. Mr. Duncan's motion is to deny case 0125, special land use for Huron Point excavating, because it doesn't meet the standards of the special land use, section A, item 1. Oh, and let me address that. The proposed use shall be of such location, size, and character that it will be in harmony with the appropriate and orderly development of the surrounding neighborhood and applicable regulations of the zoning district in which it is to be located. Item 3, the proposed use shall be designed as to the location, size, intensity, site layout, and periods of operation of any such proposed use to eliminate any possible nuisance emanating therefrom which might be noxious to the occupants of any other nearby uses permitted, whether by reason of dust, noise, fumes, vibration, smoke, or light. And item number 8, the proposed use shall not cause substantial injury to the value of other property in the vicinity in which it is to be located and will not be detrimental to existing and/or permitted land uses in the zoning district. And then additionally, section 11.14, temporary use. Item 6, subsection C, the use shall be in harmony with the general character of the zoning district.
So with my support, I'm going to just say I'll support the motion, but recommend the following amendment to it by starting, because I'm in complete support of the intent. I think maybe what we want to do is just start to say in that motion to deny case, whatever it is, based upon the information provided by the applicant, the information that has been provided through the planning commission meetings, through public hearing, based upon the application failing to comply with, bam, now you're into all your arguments. So I think it's, like I said, context is still same, it's just, I think we gotta introduce these documents to say, we're basically.
Yeah, all the information.
All the, right.
Yep,
I'm failing to meet the
I
standards.
agree.
If you're able to pick that up, then just accept that modification.
And let me read that back then. So motion to deny case number 0125, special land use for Huron Point excavating, as provided by,
Based upon
based upon
Based upon the drawings and information provided by the applicant,
meetings, public hearings,
Yes.
based on the application to be unable to comply with special land use items, Section A, items 1, 3, and 8, temporary use, Section 114, item 6, subsection C.
now Rosemary may recommend that each one of those, we still verbalize that for item C,
Which she
that the general.
He did.
Huh?
He did
We're
verbalize.
good then, we're all good with that, then we don't have to take each one and say, for C,
He did.
I know,
Yeah.
the reasons, but in the past, sometimes we've been advised that each one we gotta pick at
Yeah.
and say,
Why do we not think it falls in harmony
right.
with?
Are we good, Rosemary, with intent?
I feel that he generalized the intent for all of them,
Okay,
each one. So if you feel that the, and I get to go back, I'm just paraphrasing, and I might be saying it incorrectly. The noise, the dust, the lighting, the nuisance effect on the neighboring property is for each one of those. That would be fine. And/or if the planning commission wants to add other facts and ask the motion maker to include them, you could do so. Possibly like, the way the site plan is presented, I'm just using this as an example. You're not comfortable with the fence, that it would mitigate, a nuisance in sight or whatever. So if there's other things that you've noticed that you wanted to add into for a factual basis, you can ask, amend, and add some more facts.
you had said that the way Tim articulated now is good. Yeah, so why add and open up?
Okay. So we have a motion, we have a second. We have been explicit in our reasoning. Discussion on the motion.
I'm agreeable to his amended.
Oh, thank you, yeah. Any other discussion on the motion?
Well, I'd just like to reiterate that I do not believe the standards have been met in those, the mentioned ordinance. And I think that it's specifically because of the dust and the intensity of the activity at the location, as well as the gateway to the community that we're trying to build in the V1A district, that the proposed use is not consistent with that underlying zoning district.
So are you asking him to amend it to add that?
I'm putting it up there if he wanted to, but my feelings wouldn't be hurt if he didn't want to.
I'm good with it. If you'd like it, I'm good with it.
It's just an additional observation.
Batchel?
I amend my support.
So adding not consistent with the V1A district as the gateway to our community. How you doing on that, Melody? Co-pilot will help you out. Okay. So any other discussion on the motion? Okay, roll call, please, Ms. Oparka.
Member Duncan,
Yes.
Member Baccia.
Yes,
Member Devlin,
Yes.
Member Vyzenko,
Yes.
Member Oparka, yes. Chair Murray.
Yes. We wish you success in finding a proper location where you can take care of your business and serve the township.
Just question, where would you guys recommend in the township? Because I feel like everywhere,
We're not a recommending body, unfortunately, but And I.
So I guess, where would you guys approve if for planning and commission? Where would the planning and commission approve for what we do?
It actually was approved at the location on South River Road.
So it just have to be in that location?
Well, I think we'd want to see something with less impact to nearby residential.
It was in a marina that's already in intense use.
Okay, say no more.
Thank you.
Yeah, have a good night, guys.
Thank you, you too. No new business, correspondence, and then I have a second item that I would like to bring forward. Mr. Young, adoption of St. Clair Shores Master Plan?
Correct. Was it just a notice of adoption that they adopted their plan? Yeah. So this is a requirement of state law that after they've adopted their plan, they send out a letter. Hopefully they provided a link to where you can get a copy of their adopted master plan. So there's no action to be taken, it's just an information for the planning commission.
Okay, well, thank you.
That was easy.
Good to see other communities staying on top of it all. We're right in line and timeframe.
They got a grant like we did from the coastal management.
Well, that's good.
Oh, did they?
Yeah.
They're on
And they
top of it.
addressed resiliency as well.
Yeah, there's this resilience.
I sent out, any other discussion on the master plan for St. Clair Shores? Okay. I received an email from a resident who would like us to take a look at our ordinances and possibly make a change. I provided it to you all, and then also provided a copy to you, Adam. Compliment. I think we could take a look at this and perhaps compare. Once again, I know we're always in a position to refine and further clarify our ordinance. Perhaps we can take a look at our ordinance and some of the surrounding areas and see if maybe we can tighten this up a little bit, if we think it's worthy of tightening up. But I would like it to be under discussion, added to our list for
Yeah.
ordinance review.
So I did take a look at the comments. I think you all have it open. Really, it's two thoughts. One was with regard to parking along public streets, with the comments related to vehicles must have a current license plate, suggesting that there be regulations on no long-term storage of vehicles on public or residential streets, no overnight parking of commercial or construction vehicles, equipment, trailers, no RVs, campers, trailers, boats, pickups, such and so-and-so, except for temporary unloading, no parking within 50 feet of an intersection, and moving vehicles off the street during snow periods. What I'll say, this is relevant to the planning commission in that the planning commission's purview is the zoning ordinance. Zoning ordinance deals with, generally does not deal with streets.
As a township, right?
That is a township code issue. That's under the traffic code. That might be under the public safety code. I do know that one of these for sure is addressed under the traffic code for commercial vehicles, can't be kept on public streets. So some of these may already be addressed in our township ordinance. Some may be addressed and aren't being enforced for whatever reason. I don't know if the the person who brought this to your attention, Carol, brought it to the enforcement officer's attention either. I'm not sure. Generally speaking, I don't see anything here that we would have purview as a planning commission to address in our township zoning ordinance. These would all be either the township general code or could be enforcement, quite frankly.
Some of that
Or
parking
enforced by
stuff-
the sheriff.
Enforced by the sheriff.
Right.
Some of that parking stuff was brought up when we did our whole ordinance change for the vehicles.
The recreational vehicles,
Yeah.
Recreational
Yeah.
vehicles.
Yeah.
And, this was brought up, and this is a sheriff enforcement thing, like
Right.
I know for sure, like, no RVs, campers, trailers, boats are not allowed to be parked on the street.
Yeah, we actually said in our zoning ordinance that it has to be 10 feet from the, any street property line, in fact. Yeah,
I thought the same thing, like, I looked at this earlier, these are enforcement issues. And, you know, no parking within 50 feet of a stop sign, I think it's 25 feet by law.
Yeah, I think it
So,
is,
like,
yeah.
I don't know
Yeah.
if we have the
25 or
authority
30.
to
yeah.
make it 50.
Or the jurisdiction if they're county roads and the sheriff is enforcing these rules.
Yeah. So if I would have a suggestion, similarly for the bike path,
I was also gonna ask you.
you know, no electric vehicles, the amount of fines, you know, no golf carts, that kind of thing, speed limit on the pathway. Those are really outside of the zoning ordinance. So if I had a suggestion for this gentleman, and I know he said he already talked to Ken, the supervisor.
It says it several times.
That's the person that he would really need to talk to, or he would maybe come to a township board meeting or provide the same information to the township board. They're the ones that maybe could initiate discussions with the sheriff department, can direct our enforcement officers to take care of these violations, or the township could consider codes that they would want to adopt.
Okay.
Not to pass the buck, but that's exactly what I'm
Right,
trying
no,
to do.
and that's why I wanted to bring it to you. So the general code is
It's the township
that's the
code of
place where-
ordinances, yeah. Yeah, really for all of these items.
Well, I wonder if we wouldn't want to add to that list that maybe we should consider changing temporary uses to be like 2 years instead, at a max, rather than 5 years. I mean, 5 years to me is like not temporary anymore. And that seems like that would be something within our purview since it is in the zoning ordinance.
That is in your purview, absolutely.
I would say I would wanna also look at that and change that use permitted language to be tighter to, like, permitted uses versus special land uses.
Well,
so
and
we
it's-
don't
Right, it's a
And
way to
especially
circumvent this. by
run
not
into the
specific
chicken.
to seasonal,
Sure.
because I think our whole world has been seasonal.
Yes.
Now
Yeah.
we have an opportunity to take into consideration a bigger deal.
Yeah, and I mean, it could clarify that the intent is to be seasonal and not disruptive and not a way to circumvent the special land use process.
And we can look at those standards. Yeah, we can look at, you know, tweaking the definition of what a temporary use is.
Just tighten it all up. So it's clear to everybody, including an applicant and the township supervisor.
Yep, in the past, under that language, we've approved temporary tents, seasonal sales.
But for
The one
like
that I can think of
4 weeks.
at the marina was summer boat sales, I believe, or wet season boat sales on a marina property or something like that, so.
Which, and we've imposed in those cases sometimes some really strict, requirements.
Okay. So, a couple of things to add to our list for future consideration. Thank you for addressing the one residential item. Any other discussion for correspondence? Comments from the planner?
We had a tech team meeting last week. We heard 2 cases. One was from the Huron Clinton Metro Parks, so at the beach. They are looking at making improvements to their north marina, expanding the seawall, the dock area, and they're actually looking at reconstructing the restroom facility there. So some of the seawall improvements, I think, had already been permitted by Eagle. So some of the grading and some of those improvements were approved by the tech team, but the building, the new restroom building, would have to come before the planning commission, because it's large, it's a pretty good sized building, actually. So that may be a project that we'll see in the future at the planning commission level.
Okay, good.
The second case was the former hospital property
Oh,
on Ballard.
yeah.
if you recall, that property actually extends all the way to Campo on the other
Yeah,
side.
Campo.
And there's maybe, I want to say 800 feet or so of frontage along Campo. And they were looking at, well, could we split off some of those properties?
Oh, yeah.
For residential development?
Yeah, 13 separate
Yeah,
lots.
yeah. So there's a lot of things to consider. We went through a whole bunch of scenarios with them. One of them being that it could be wetlands on that property too, or that probably the first thing they'd want to look at is do a wetland delineation.
And
see.
access points?
Well,
That's kind
I
of
think
a
first they need to figure out,
Sandwiched?
first they need to figure out the wetland. How much of that frontage, if any, can actually be developed.
Okay.
And depending on that, they might consider single-family homes or a condominium or, I don't know. So there's no decision on that one. That was just a discussion only.
Anything else?
That's all I have for you tonight.
Okay. Comments from the floor? Mr. Bardell, how are you doing tonight?
Good. I had a question. When we sign our agreement with the Macomb County Sheriff, is there a way that you guys can dictate what is indeed a civil infraction and what's not? As far as I know, you just talked about, the street parking and all this other stuff, and you had indicated, and I'm sure a lot of residents raised a lot of, HE double hockey sticks about the enforcement issue. So are you indeed agreeing that there is an enforcement issue? Because there's some disconnect between the sheriff's department and what we're considering a civil infraction. There's a disconnect there. So what are we enforcing? Because a lot of times you call the sheriff's department and you tell them what township you're from and they'll laugh. So something's going on. I mean, honk the horn, raise the bell, hit the, whatever. There's a disconnect there on what is the civil infraction. Who's going to enforce it? It's the ordinance officer. No, it's the sheriff. Who's actually doing this? Do we have a king? Do we have what is there's a disconnect there. So this resident that talked to you, and he obviously went to the wrong, he talked to you, but I'll just say, they don't make sense. And I want to talk to you a little bit after the meeting about a few things. Thank you for listening.
Thank you. Our next meeting, Thursday, March 20th, 2025. May I have a motion to adjourn, please?
So moved.
Support.
Ms. Devlin, Ms. Oparka, all those in favor?
Aye.
Opposed? Motion carries. 8:20. Thanks, everyone.
Yep.